My name is Marina. I'm a professor at FGV Direito São Paulo, and I am here today with Alexandre Pacheco to interview a wonderful person that is Anthony Davis, who gave us the honor to write a paper about artificial intelligence and the future of legal professions. And today we are going to talk a lot about his article, and also, but first I would like to introduce him. Anthony Davis advises lawyers and law firms in the United States and internationally in the areas of professional responsibility, risk management, and every aspect of law governing lawyers. Anthony is the author of books, numerous scholar articles, and has a column in the New York Law Journal. So it's an honor to have you here, Anthony. And I would like, before to make some questions, just Alex to say hello.
It's my honor to be here. Thank you for having me.
It is indeed a pleasure to have you with us today, Anthony. And we have a lot of questions to actually present to you. And we are eager and excited to hear your answers throughout this afternoon. Thank you to be here with us today.
Thank you again.
Anthony, we would love to hear more about your professional career and how you got to study legal professions. But since we studied here in Brazil this topic as well, about all the changes that we are facing in our profession, we would like you to know, how do you feel about the fact that now companies prefer to have or invest in their own legal department instead of hiring law firms? I don't know if you actually agree with this, but we saw a lot of this movement here in Brazil that companies would say, oh, I know more about my business than some lawyers, so I will invest in technology and all lawyers inside my company. So how do you feel about that? How do you see that movement in the US and UK, that I know that you talk about a lot about that?
I doubt that has a lot to do with technology, Marina. I think mostly it's out of two very closely related concerns. One, companies like individuals don't like paying outside counsel legal fees because they have no control. And they hire in-house because they control the spend. They know how much their legal work is going to cost. And they bring more and more people in as their needs arise. And secondly, and related to that, it means that they can focus the lawyers that they have on their particular needs and make people expert in their systems, their businesses, their concerns, their legal issues, in a way that it's harder to do with outside counsel. It's not impossible, but outside counsel have other priorities, other clients, and the in-house team is dedicated and devoted to the needs of the company. By and large, going to something we'll talk about later, I think, they use the in-house folk in two ways. First, they use them to do all of the routine work that is much more easily managed and made efficient by having a dedicated group of lawyers. And secondly, to the degree they need expertise at the senior level to advise management, again, they have the availability of people they have specifically selected to serve the needs of the higher levels of the company. So I think those are the two things that are going on. Do you see something else?
No, it's just I think that especially here in Brazil, that means a lot of changes in the market, because usually companies have few in-house lawyers, and they delegated a lot to law firms. And now this movement it's changing a lot. Especially they say that is not only because of technology, but also because of the business, as you said, that they know a lot about the business. So I think it's basically the same, but I think it's a challenge for law firms to think about that.
Well, law firms in this kind of environment then become, hopefully, the place where the company's higher needs are met, not the routine, so that hopefully what work is left for outside counsel is the unique, the one-off, the new, the specialized, where, you know, I mean, whatever it is. I mean, some companies are big enough to have a team of intellectual property lawyers doing their own IP work. Other companies may have needs for different kinds of lawyers in-house, but relatively little IP work, so that's what they'll send out, the stuff that they don't have the capacity to do efficiently and effectively. So it's a realignment of work, I would have said. But it emphasizes the need for outside counsel to have a genuine specialty, to be you know, recognized as the leaders in particular areas, so that companies come to them because they don't have it in-house. They don't have the need, or they don't have the capacity, or they don't have the expertise. But that means you know, law firms have to have, they can't anymore be, you know, general counsel. They're going to need to be able to say, we can serve you in the specialized areas that you need but don't have in-house. So it's it has to be a symbiotic relationship, I think. But it also makes it harder, and we'll talk about this about law schools later. It makes it harder for law firms to train lawyers to be the experts, because the clients come to law firms in this environment because they don't want the junior lawyers' work. They need the expertise of the senior lawyers, and that is an attack on the old model.
And speaking about models, one thing that caught my attention reading the paper that you wrote for us, Anthony, is that in your paper you mentioned that lawyers of the future will not need to be able to code, or they do not need to actually have the ability to program software. But they will need to have an intimate and continuing understanding on how to identify and use AI solutions, artificial intelligence solutions, to meet their client needs. You mentioned also that, for example, the London-based global firm Linklaters announced the creation of a special track for lawyer skilled this way. My question for you is, what about small firms? What should a small firm with limited resources do to survive this technological scenario? And how can lawyers that work in small firms prepare themselves in this scenario?
Well, I think we may find that generalizations are difficult, but I think what's critical is to understand why clients are coming to the small firms and what needs they're answering. I mean, we could take two different kinds. You know, if it's a small firm serving individual clients, there are two sets of issues. On the one hand, if they're doing decedents, estate, trust and estate work, family law matters, writing people's wills, transferring their homes, their competition is the software that can do the same work without needing a human interface. And so their challenge is going to be, how can we embrace the technology and give the clients the value of the technology and then add something on? But I think that's hardest for firms with what I used to think of as a general practice. I think it's going to be very hard for a lawyer to be a jack of all trades, to know everything, to answer everything from a criminal law problem to an intellectual property problem to a real estate problem. I think that lawyer of the 19th century, that lawyer is a dinosaur, because they can't do anything as efficiently as a specialist, and they can't know enough about what the software tools that are available to them and to clients in all these different areas. So I think the answer is, and I don't think the challenge in the future is large firm, small firm. I think the challenge is that every law firm is going to need to understand that it's competing with an ever-growing universe of technological solutions. And so to answer your question about what lawyers are going to need to know is, what are the solutions and which ones are the best for their clients? Which solutions are going to give the fastest, cheapest, and most accurate answers? And that means, again, it's another kind of specialization. You have to know not only the area of the law that you're interested in, but you have to know what are the most up-to-date tools that you can be using. That's not so hard if it's a narrow field. As I say, the more services you say you're going to offer, the harder it is to say, I'm up to date with all the technologies. And it's a challenge. The one challenge that small firms have, that, as you mentioned Linklaters, that a firm like Linklaters is able to do, it has, the large firms have the ability to set up groups to do the evaluation of the tools that are available for their clients' needs. So that when the lawyer says, I've got this kind of a deal, the technology group can say, fine, here's the latest technology to use. We put in the data and we get out the best results, and then you counsel the client on how to use the result to their best effort. But that's harder for a small firm. Which is why, in a way, the narrower the focus of the small firm, the more likely they are to be able to stay up to date and to do that work. Does that make sense?
Yes, and you say like that it's not about small firms and big law firms, but it's more about what type of services that you offer your client. And I hear you saying a lot in your article about these new actors that are getting stronger, like editors, Thomson Reuters, like Synaxis and law text and legal text. So I would love to hear from you about, so what is about and how can we regulate all these new actors that are coming?
Well, that's the most interesting challenge. And traditionally, the regulators of lawyers have said, okay, we know what lawyers do, we know what qualifications they have, we know how to regulate them. They're the people who provide legal services. We protect the public by regulating how lawyers operate, what they do, and how they provide their services. Now you're in an environment where an awful lot of what used to be done by lawyers can be done using a piece of software. In this country, you can fight a traffic ticket just using a robo-lawyer, just using a piece of software. Now, I was astounded the other day to pass a storefront in downtown New York City which said, we fight traffic tickets. I cannot believe it is economic to hire a lawyer to fight a traffic ticket. It can't be. But it is economic to pay a software provider $15 and get all the steps you need in your jurisdiction to challenge a traffic ticket. And so the issue is, who regulates the provider of the software that says, we'll show you how to fight a traffic ticket? Because the regulators and lawyers haven't got a clue whether it's good software, whether it's got biases in it, whether whether it actually does what it's supposed to do. That's not what traditional regulators and lawyers have ever done. And so what I think we need to think about is and I think the Europeans are starting to look very carefully at this. We need a system that says we're going to have a regulator of legal services, not a regulator of lawyers, but a regulator of legal services. And if you're selling to the public, we fight traffic tickets, we're going to regulate you, and we're going to have regulators who understand technology and who can assess whether you are actually capable of doing what you say you're doing. And whether or not we say you have to have a lawyer on board, what the regulations are, that's for the future. But one of the things that I think will eventually have to happen is, in most societies, they won't be able to say you must have a lawyer involved. I don't think they can do that. I think it's about, what is the service you're providing, and is it truthful and accurate, and does it do what it's supposed to do? Then we'll allow you to do what you want to do, and you can regulate by saying, before you start selling, you have to explain, you have to give us the software, we have to be able to have a technologist review it and see how it works. And to go to Alexandra's point about the lawyers have to code, some people say that it's useful for the future technology lawyer to know how to code. My sense of the world is that there are more and more software developers who develop good AI programs without the need for coding. There are very simple tools that help you create the services you want to create without having to know how to code. Somebody did that. Somebody gives you little segments that you put together in the way that you want to, that you fill in the data that you need to fill in, and it develops the answers. Now, may it be useful as a kind of grounding to know how coding works? Perhaps. I'm not going to say it isn't. But I don't think that's what this is about. And some law firms do develop their own software tools, and that's great. And they need technologists, and they need people who can code or who can use these tools to assemble software. But the person who and those people, along with somebody who understands the legal issues being addressed, together can develop a tool. The lawyer at the end of the day is going to say, okay, we've got this tool. It tells you, let's talk about a tool that evaluates the strength and weakness of a case and gives you a predictive analysis. This case has a 60% chance of success based on the court it's in, the nature of the issue, the side that you're on, the arguments that you have. You've got a 60% chance of success. That doesn't tell the client something critical. How much is it going to cost? Is it worth the risk? What would happen if we lose? How long will it take versus alternative solutions? That's what the lawyer's going to, it's what I call the last mile problem. Technology is going to do a lot of the grunt work, the groundwork that lawyers used to do in order to get to the last piece. And it's going to help lawyers and clients do a lot of the grunt work and the basic analysis. At the end of the day, though, somebody's got to make a judgment, make a decision. Are we going to do this or are we going to do that? That's the place where you have to take the outcome of the technology and use a lawyer. On the other hand, I was looking at a presentation recently. You know, there are some tasks that you can give to technology and to a lawyer. Look at this non-competition clause in this jurisdiction. Is it binding and effective, and is it properly written? And one of the companies that has a tool for doing that evaluation set up a challenge. Now, it set up its own challenge, so whether we can trust the results, we have to make our guess. But what it says it found was the software got the right answer 94% of the time. The top level lawyers got the answer right 94% of the time. But if you gave it to a law firm and spread the work among different levels of the law firm accuracy went down to 56%. So now the client has to say, okay, lawyers are going to charge me 10 hours at $1,000 an hour to get the answer. The software can look at one of these clauses every 5 minutes and give me an answer as good as I'm going to get for 10 hours of work. Which would I like to use? It may be wrong sometimes, but the lawyer can be wrong sometimes. But it's more accurate, it's faster, and it's cheaper. Now, the lawyer's job is to say, do we need a do not compete clause, non-compete clause? And can we use the same clause? Well, the software can say you can use the same clause in lots of countries, lots of jurisdictions. But what's the business case as a lawyer for using this clause and forcing it on clients or on the other side? Those are the things lawyers are going to be doing. They're not going to be drafting the clauses. They're just not. It doesn't make sense. There's software now that drafts the pleadings, the papers that you put into court to bring a case against someone. It's not the best pleading you ever saw, but it takes the computer 20 minutes to generate it. If you give it the facts and the names of the parties, it takes an associate 3 or 4 hours. A partner's still going to have to review it, whether it's the 3 or 4 hours or the 15 minutes, to clean it up and to make it right. That's the challenge. And my point is that challenge faces law firms of every size. And clients, the only thing that's slowing this down is that clients are conservative. And lawyers are conservative. And people are frightened of technology. But that's going to pass. I mean, the generations after us, I mean, look, when I was a child, the idea of this kind of video conference was science fiction. The idea of a smart watch, that was Dick Tracy, that was a cartoon. You know, the iPhone first issued in 2007. That's only 15 years ago. But everybody who's come of age, anybody who's 25 or under, assumes that universe. So the assumption of the next generation is that we're going to use technologies and new technologies more and more. And so merely going to somebody's nice law office, a fuddy-duddy law office with nice pictures on the wall and books behind them, forgive me, Alexandra, that's not the future. Who needs books? That's what the internet is for.
But I have a question regarding this specific argument that you present to us, and it's been fascinating hearing from you. One thing that I'm thinking, hearing from you, it is that we need to change some concepts that we have, for example, to regulate the legal profession. One aspect that you mentioned in your paper, it's the possibility of malpractice regarding the choice between use AI tool or refuse to use a AI tool. So my question is, do we need to include a new aspect for the regulation of the legal profession? For example, one thing that you mentioned, it is transparency for AI tools and trying to not resolve or not to solve the problem of AI bias, but at least mitigate some aspects of AI bias. But this is not, those are not topics for the regulator for bar organizations all around the world. So my question is, how big is this challenge of regulate the legal profession when we are trying to use those tools in the future?
I mean, the problem is, I don't think the regulators even understand the existence of the issue. You're assuming that they're aware that there's a problem. I mean, to my mind, this is first and foremost. I mean, look, the regulators in this country now say lawyers have to have technological competence. I have no idea what that term means. And my point is, it means something different in every sphere. But what it does mean is somebody in the law firm better understand, A, what tools are available, so we're using the best tools for the clients, and B, how they work, and C, what the other competing products do, and be able to tell the clients, here's the one we want to use, here's why we want to use it, here's what it will do, here's what value we add afterwards. Now, the it was actually a litigation that came out the decision came down last week. A major insurance company sued a small law firm for not using adequate technological supervision, as a result of which the insurance company said privileged, confidential, private data was released, and that the firm hadn't used adequate technology. And the firm won. They said, we used the appropriate level of technology, and people get hacked, and, you know, bad things happen. But you can't say we weren't trying. We met the level. But those cases are going to happen, but it's going to be the marketplace that decides. And in this country, at least, large corporations lay down the rules as to what technology law firms will use, and what levels of security they maintain, and what tools they will use, and where the data will be kept so that it's safe. Many corporate clients are laying down what they require lawyers to do. And that, to me, is a much better regulator than somebody, you know, in a government office saying lawyers must be technologically competent. The hell is that? But I know as a client what I need. So clients are going to do some of this regulation themselves, the larger clients. And when the larger clients set the standard, that's going to become the standard for everybody. But there's no doubt that AI has, I'm doing a program specifically about the risks that AI has, but it has the risk of negligence in lots of different ways. It has the risk, you talk about regulators, I'll tell you where regulators is going to come in, or the market. If I bill you for 10 hours of work, that I could have used a software package to produce the same answer, and if I had a license for the software, it would have cost me the equivalent of 1 hour of work. Have I billed you improperly? Should I be able to collect for the 10 hours as a matter of regulation of lawyers? Or if we're protecting the public, should we say lawyers can't charge an excessive fee? And it's excessive if you can get to the same result a different way. So it's not that there'll be no role for regulators, but I do think it's secondary, because if we talk about the fee issue, the very simple regulator of that is, where's the client going next time? Don't go back to that lawyer again. That lawyer is going to be out of business. And that is a problem for the smaller firms that don't have the ability to say, this is the software tool, we should be using and we need to use. And it's a problem that my generation of lawyers generally, and anybody over 25, it's not ageist, it's about what we've grown up with and what we understand technology can and can't do, and what we're willing to learn. But we're,
sorry.
It's fine.
It's a question that is related to that, to this new generation. And in your article, you say that there will be a place for some human abilities such as judgment, empathy, creativity, and adaptability. So we are very interested because as a law school, what kind of training can we offer our students to develop those abilities through this?
All right. It's a very tough. I mean, let's go back a step before I answer that.
Okay.
The first thing is, I think law schools have a duty to the students to say, this is not the 20th century and it's not the 19th century. And you are not going to be able to serve your clients without understanding technology. And here's what the technologies are, and here's roughly how they work. And here's where you go for help to figure out which ones are the best, since there's no public entity is grading the technologies, giving them an A and a B and a C in their categories. Eventually, we're going to have to come to that. Eventually, there's going to have to be some kind of licensing authority that actually does evaluate the technology, makes the companies produce their algorithms, so it's not in a black box, so we can evaluate whether they're biased and what the biases are. We're not there yet. We're not there yet. But so lawyers at least going to have to understand the environment. In terms of what lawyers are going to do, as I say, lawyers ultimately value is the last mile. How do we use the results of the technology most effectively? How do we pick the technology? How do we decide what level of sophistication we need in the outcomes of the technology? I think it's a huge, I think what you're asking is a question that I don't know what the answer is, and I don't know if anybody is. How do we train lawyers for those things? I actually think if you really want to answer that question, you are in the wrong faculty. I think you need to be talking to the sociology faculty, and you need to be talking to the psychology faculty, and you say, because there are people writing about this, how do you train judgment? But they're not in law schools. They're in other faculty, they're in other parts of the social sciences. And so that's where you should be looking for those answers. You should say, what can we do to develop courses that help people develop better judgment so they're more valuable to clients?
Yeah, that's wonderful. And even in Portuguese, it's hard to even translate judgment in Portuguese. And I agree with that. And we have to take very serious all these abilities and put it in our curriculum in an explicit way, because we don't say that law schools teaches empathy or creativity and all those. So we have to take
By the way, who law schools admit, the psychologists will give you tests that you can use to differentiate the potential of the students that you want to admit. There's no question about this. You can go to the psychologist and say, give me a test that will evaluate the ability to empathize. They will give you a test. That's what you have to do, so at least you have the right raw material in the classroom. The ability to memorize statutes, forget it. Technology is going to do that.
And just to add something regarding this argument, do you think that the changes that we will see in the future regarding hiring models will need to include those aspects in how employees will actually hire future lawyers?
There's at least one law firm in this country that's already doing that. to using those psychological tests to evaluate incoming lawyers. Because they know in the end, to be the provider of the last mile solution, you've got to be able to relate to the client. You know what 30 years ago was called emotional intelligence. That's what this is about. If the lawyer doesn't have that and is merely a mechanic, the best that mechanic is going to do is work for a software company to develop the tool that will do it faster, cheaper, better.
Just going to say that now we are going to the end of our interview, and Anthony, I would like you, if you could just give a final word about all of these, and what do you say to a young lawyer at the end of the day, an advice or something that you would like to share about all the experience that you have on counseling? What would you say? And I would also like you to thank you very much for this wonderful interview, and it's such a pleasure to hear from you.
Well, I mean, you met Professor Pierce at Fordham, and I sometimes do this, answer that question to his classes. And my answer is this: the universe of law jobs is going to expand. I mean, technology always has that effect, or it hasn't historically always had the effect. New technologies increase employment, but in different ways. And my view is, going back to Alexandra's very first question, I think it's the large firms that are going to be challenged more than the mid-sized and small firms, because the large firms have built themselves on this model of leverage and, charging out associates. That cannot be the long-term model for law firms. The future, but on the other hand, there are going to be jobs in technology. There are going to be in-house jobs. There are going to be jobs for providers of solutions, research companies. Publishers are going to need lawyers who can use the tools better than in-house department and better than the law firms, because that's what they do all day long. And they develop, as the tools develop, they have the specialty to do it. There are going to be lots of different jobs for lawyers. But the law firm is going to change. It has to change, because clients won't pay for the traditional model much longer. And so think very carefully about what strengths you have as a student, what you know about technology, what you want to do, before you say, I'm going to go to the traditional law firm model. And a lot of the technology companies look for and take lawyers from the big firms and say, you've shown that you've got an idea and an aptitude, come and help us develop our products. So there are going to be, to go back to my, fighting traffic tickets, the guy who developed that software is not a lawyer, but he had to use lawyers to develop the software, and he has to use lawyers to keep it up to date. So there are roles for lawyers that people never thought of, but it's not the guy in the storefront that I passed this week. We fight traffic tickets. That's not the future.
Thank you very much, Anthony. I think that was an amazing conversation regarding the challenges for the future, regarding skills for lawyers in an environment full with technology, especially AI tools, that represents a huge challenge for the model that you speak about throughout our interview. So thank you very much to be a part of this project. And for our audience, see you next time. Thank you, Anthony.
Thank you very much for having me, and have a great day. Good luck, everybody.
Thank you.
Thank you. Bye-bye.